So the court's going to impose the following sentences. In count 7, aggravated burglary, it's a felony of the first degree, 11 years in Lorraine Correctional Institution. In count 8, it's kidnapping. With respect to victim Suzanne Taylor, it's a felony of the first degree, 11 years in Lorraine Correctional Institution. In count 11, which is gross abuse of a corpse, with respect to victim Suzanne Taylor, 12 months in Lorraine Correctional Institution, that's a felony of the 5th degree. In count 9, kidnapping, with respect to victim Taylor Pifer, 11 years in Lorraine Correctional Institution for that felony of the 1st degree. In count 12, gross abuse of a corpse, with respect to victim Taylor Pifer, 12 months in Lorraine Correctional Institution. In count 10, kidnapping, with respect to victim Kylie Pifer, felony of the 1st degree, 11 years in Lorraine Correctional Institution. In count 13, gross abuse of a corpse, with respect to victim Kylie Pifer, 12 months in Lorraine Correctional Institution. The sentence will run consecutive to each other. Count 7, consecutive to 8, 9, 10, 11, 12, and 13. 47 years in Lorraine Correctional Institution. Pursuant to our statutory duties as well, with respect to this death sentence imposed, these underlying sentences are consecutive as well. Post-release control also must be addressed on the underlying counts. Post-release control is a mandatory period of 5 years for the felonies of the 1st degree. If you are ever released, you will be supervised for 5 years. It's mandatory. On post-release control, you must follow the rules of the parole authority if you are ever supervised on post-release control. If you fail to follow the parole authority's rules, they have the power to send you back to prison for a total up to 50% of this original sentence. Any violation of the parole authority's rules could result in a residential sanction, which could include a new prison term up to 9 months. Those rules on post-release control will require you to report to a parole officer. If you ever fail to report, the parole authority may punish you by sending you back to prison. You also could be indicted on a separate felony called escape, which means that judge assigned to that new indictment can also punish you with time in prison. Even if the parole authority also punish you with a prison term. That's also true of any other felony you might commit on post-release control. Parole authority can punish you for that felony. The court assigned to the new indictment can also punish you. If you are convicted of a felony when you're on post-release control, the sentencing judge will have an option to impose a consecutive prison term for the amount of time remaining on post-release control or 12 months, whichever is greater. You do have a right, appeal as of right with respect to these matters. We had previously found the defendant indigent. Would you like us to appoint appellate counsel as well?
For sure.
Our specific findings will be journalized in a written opinion and filed with the clerk. The entire record will be transmitted to the clerk of courts and preserved for appeal. This is defense asking for jail time credit.
Yes, Your Honor.
Is that an issue? Have you calculated the days?
We have not. So we will.
One moment, Your Honor.
Yes. We're also imposing court.
And Mr. Brinkman has made it clear to us, as he has early on in this case, that he does not wish to appeal your decision.
Mr. Brinkman, is that correct?
That is a true statement, sir.
Have you had enough opportunity to talk to your attorneys about what the appeal entails and how it would proceed?
Yes, sir.
Do you have any questions about that for this panel?
No, sir.
Pursuant to our statutory duty at this point, and having considered what defendant's wishes are, the court is going to appoint appellate counsel so that if there is any possibility of this defendant wishing to pursue specific issues that may occur to a counsel, we will appoint the State Public Defender's Office and another attorney with respect to an appeal. Also, the State of Ohio has a request as well for the sentencing date.
Yes, Your
Honor. Considering that this sentence is not final judgment until our opinion has been filed with the clerk's office, I'll set the execution date for January the 15th, 2020, which will be 1 year from when approximately the sentencing memorandum and opinion would have been filed. Is there anything else for the record from the State of Ohio?
Two things very briefly, Judge. Number one, from the date of the defendant's arrest, I believe he is entitled to 564 days of jail time credit, so we ask the court to award him that amount. And number two, there was one consecutive sentencing finding that I believe the court did not make, and that was that consecutive sentences are not disproportionate to the danger the offender poses to the public, so we just ask the court to make that final as well.
All right, if I didn't say that, I thought I did indicate that, that the consecutive sentences aren't disproportionate to what happened. It's also not disproportionate to the danger he does pose. That's correct. I appreciate that. Incorporating all the facts that this panel has heard. The court will grant 564 days jail time credit pursuant to law. Is there anything else for the record from the state?
No, Your Honor.
Defense?
No, Your Honor.
All right, defendant's remanded. Recess.
All rise.